Greetings, welcome to THCTrust.org. If this is your first time with us, make sure you visit the website www.thctrust.org. Basic membership is free, at least as of right now, and if you would like to support our efforts and have access to our templates, you can join the premium subscription group. So when you first go to the website, you really don't have access to the resources until you log in. And if you don't already have a login, make sure you come down here and create an account. So we're going to go ahead and log in. And today we're going to talk about, really talk about the Rule 5.1 Constitutional Challenge. And we're going to give an overview of the commercial crime matrix, which is something that I've been working on at thctrust.org. Primarily because last month, right up to the beginning of this month, I was dealing with a criminal matter where the fictitious state of California was trying to charge my person with a few felonies to escrow funds from my estate. Now, basically, in normal terms, for people that probably don't understand what I said, the state of California or the county of whatever, all of these are fictitious entities. They are not living men or living women. So that creates a problem because for these entities or these fictitious agencies to charge a living man or a woman with a crime is basically illogical and impossible and incorrect. So anytime that a fictitious agency is bringing a commercial crime against a man, it's basically a false claim. But in reality, they avoid that because technically, contrary to our ignorance, they're not really bringing a claim against the man. They're bringing a claim against the name, which is an estate. And I'm not going to go into all that because I'm certain that if you're here watching this video, you probably understand a lot of that. So what we've developed, and let me go ahead on down and show you here. Down here under the criminal remedy, which I've just now started to finally have the time to start working on, primarily because, like I said, I had a situation that I had to work on for myself, which is now favorably resolved. It's not completely resolved, but it's favorably resolved. I've got it resolved on the public side thanks to a lot of what I'm about to share with you in here, but now I'm still going to discharge it in full acquittance on the private side, which is going to eventually be step 3 right here. I know a lot of people go to the website and they're looking for how to discharge debts, and I haven't really filled that out yet. But in reality, if you followed the rest of the website, especially the last videos that I was kind of doing under the, where is it at? It's under the under occupation military law, where I talk about admiralty, the Lieber Code, and the Trading with the Enemy Act. Well, the remedy is written right in there. And so when I fill this part out, I may give someone access to it, or if you're a premium member and you don't have access to it and you feel that you're in a situation where you really need it, then go ahead and shoot me an email and contact me. What you see here under this commercial crime matrix, so to speak, I've created a 1 through 8 step process. And all of these are kind of like individual processes within themselves, but you can also look at the entire thing as a collective process. And the collective process is solely for the purpose of shutting down any criminal proceedings against the man by any means necessary. Alright, so what you see here is what we are calling the commercial crime matrix. And the only purpose of this is to shut down court processes when they try to process quasi-criminal complaints against living men and women. The purpose of this commercial matrix is it's a collection of tools that have a certain sequence and a flow with them to aid you in shutting down these quasi-criminal proceedings by any means necessary, as quick and as soon as possible. And as I learn things and as people share things with me, this 1 through 8 step process will it'll continue to grow. Now, I also want you to take note that this is like one whole process, but in reality, each of these are individual processes within themselves that come together. Like, you remember the movie, not the movie, but when I was coming up, we used to have like Voltron or Trans or Z. It was these cartoons about all these individual transformers, I guess, if you will, and that when they all come together, they form an even bigger one that's even stronger. That's kind of the concept of what is going on here. I was planning on creating this commercial crime matrix for a very long time, as I am creating other matrices on the website. It seems like the creator put me in a situation where I had to pretty much drop everything else and go ahead and immediately start creating this. So I'm kind of thankful for this, because I created it based on my personal situation, but at the same time I was conscious and aware enough that I was, there was some emotions wrapped up into it, because it's a little fears and things like that we all have to work through, that I definitely had to work through. But I think I maintained a pretty clear head, and I really seen a lot in my research and my preparation to prepare this commercial crime matrix that I'm going to share with you now. Actually, we're going to only go into the constitutional challenge, which is what I find makes a very good first step in trying to shut this thing down. But I will also say I had prepared all of these documents and templates, and I had did the research on all of these, and I was ready to rock and roll, and I really only got through about one or two of them, and some pretty amazing things happened on the public side, which opened the door and gave me a remedy to get myself out of harm's way. But I'm not going to say that everything is complete yet, because what I'll still be working on the private side is a discharge of the case in full acquittance, and my hope and expectation is to have this whole thing removed from the public record. Alright, so this is Rule 5.1 under the Federal Rules of Civil Procedure. So these are the basic rules that apply to all federal lawsuits, and this happens right at the this rule is headed under a title that says commencement of an action. But anyways, Rule 5.1 allows you to challenge the constitutionality of a state statute or a federal statute, and it gives you the specific instructions of how to do that. Basically, it tells you to do so. It says, and I'm going to read right here: serve the notice and paper on the Attorney General of the United States if a federal statute is challenged, or on the state Attorney General if a state statute is challenged, either by certified or registered mail, or sending it to an electronic address designated by the Attorney General for his purpose. Now I'm going to put a couple pieces of the puzzle together for you, things that kind of clicked and were put together in my mind based on other areas of research I did. I'm going to try to tell you what I think this is all about and what's going on behind the scenes here. Now, mind you, in my particular situation, I sent off this document and I sent some other documents to the county when I was asking for a proof of accounting, because I was about to extract the information to prove that the judges were receiving improper payments from the same county that was trying to prosecute me, creating a conflict of interest. So even these inquiries are very powerful inquiries, especially when you have the competency and the understanding of what you're asking for and what it means when you get the information, right? I think that makes more things happen in the background that you're unaware of than you could ever imagine. I said that to say, so let me put a couple of things together that I've realized. The first is constitutional rights only apply to private citizens, right? And this is, when you look in the public, as I mentioned in other videos, they're operating under bankruptcy law, they're escrowing funds from estate, which is the foreign law and how they deal with estates, and they're operating under martial law, military law, admiralty, and everything else. So this is your public law. This is why you don't have constitutional rights in the public, because they're under military occupation. Now, one thing that we do understand is in the public, in a public form of law, the contract is what holds all the weight. This is how they're kind of doing their bankruptcy or escrowing funds from the various estates. They're letting foreign creditors come in with legit contracts or non-legit contracts, quasi-contracts, fake contracts, but the end result is the same. If the debtor doesn't know how to challenge the contracts, then all they have to do is come in with the contract and liquidate their claim, or create funds off the estate, escrow funds from the estate, whatever you want to call it. Okay, so now, I also remember when studying the Lieber Code and martial law, that you will find that many of the magistrates and other officials have to take an oath to the foreign occupation. And you have to remember, they're doing business of the foreign occupation. They're basically collecting. And there's all these federal laws about collecting debt, not just the FDCPA. And remember, we also learn that the judges are foreign agents. So they're foreign agents doing business for foreign creditors in the estate. Now, if you put this into the proper context, in order to do that business, this is why they have to have that oath of office and the insurance under the insurance backing up the obligation set forth in the oath. So if you can understand that, then it'll be clearer why I said to you that the Constitution is for private citizens and it's private rights. This is the only contract that you have with these quasi courts, because in order to do this risky business that they're doing, they are required to have some form of insurance. That's the oath, is the contract that you accept for value, and that gives you an enforceable right to the collateral associated therewith, which is the insurance policies. That's basically exactly how it works. Now, this is important because when you get into the discharge, you start talking about appointing and giving, appointing an officer as fiduciary, an appointment that he can't refuse, and then you directing him and giving him an order to do specific things that he's required to do by law. And now you have a binding and enforceable interest in that oath of office, and not the oath, but the insurance policy tied there too, if things don't get done the way they are supposed to be done by the law. And then plus, if they're not done, you have all kind of violations of the Trading with Enemy Act, and false representation, misprision of felony, RICO, and other things. Now, again, we were talking about that 8-step process. All of that is towards the end of it. And when I was saying earlier that I also sent inquiries to the county to find out about how the judge is receiving payments, that is under the FOIA request, which is also under those steps. Anyways, I was just kind of talking about the Constitution being for private rights, because I wanted you to understand that the Constitution is the only enforceable contract you have with these courts. And if you've ever been dealing with criminal matters, or you've ever seen other people dealing with criminal matters, even those totally in the matrix, those who mostly have success are those who lean on their constitutional rights. So everything that we're about to do in this constitutional challenge, which is for the purpose of shutting down this quasi-criminal action, we have to do it in light of the constitutional contract that we hold with the state, that they're required to enforce, or to protect, or to support, for lack of a better term. So how this would work is we would send this constitutional challenge off to the Attorney General as soon as possible, challenging the constitutionality of a state statute. Now, we would be sending this to our state Attorney General in most cases, unless we were dealing with a federal offense. Now, this is the problem. So this is why these offenses are not constitutional. Well, foremost, because most constitutions, federal and state, have a specific process which defines which codes, statutes, ordinances, or really their bills, become law. So the way that you look at it is, there's obviously thousands of laws on the books, and we can't be expected to competently know all 100,000s of laws. So your Congress sets forth a specific process for enacting a bill into law. It has to pass through the House of Representatives, then it has to pass through the Senate. Most of the codes and the statutes that they use against us have not been enacted into positive law, meaning they have not officially passed any legislative body to become law, and therefore there's no proof that they are law. So that's one constitutional challenge right there. Constitution sets forth what the law is. Show me that these have been enacted into positive law. Another constitutional challenge, which is the more of the direct one, is the one that I bring that deals with slavery. All constitutions have outlawed slavery or made it unlawful to force involuntary servitude, right? So another question I ask is, show me how a certain statute could be, constitutional when it's being forced on the man without his consent, without his, without his will. He's not receiving any benefit from it. He's not participating freely. It's being forced upon him so someone else can make money. By all definitions, that's slavery, and slavery has been outlawed. So that's another very powerful constitutional challenge. And there's actually several more. I put like 3 in the template that I'm about to go over, but I was kind of just showing you some of those to say that it's pretty apparent that the Attorney General is not going to talk about these things. And I'm certain that they won't talk about these things because I've researched, and this is really just straight up slavery. There's no way around it, and no one's going to admit that on the record, and she's definitely not going to speak against it and say that these things are not constitutional, because she would be indirectly indicting the whole quasi-judicial system, and that's not going to happen. So usually I think the best thing that can occur, and probably hopefully will occur if you use a similar strategy, is that they're going to open up a doorway and give you a very good out in the public. So don't be belligerent at all. If you see an opportunity to get yourself to safety, which is likely their only way, because like I say, they're not going to openly admit to anything, then maybe you want to take that and then get yourself out in the public and deal with the rest of the issue on the private side. So let's go ahead and look at the Rule 5.1 Constitutional Challenge template. Okay, so another thing I want to mention before I read this is one of the other reasons why we want to default them with the constitutional challenge. Because see, what's supposed to happen is, the Attorney General has up to 60 days to respond. Now typically, because of the nature of the challenges we're bringing, it and their truth, we're really bringing truth, but it stands to expose the fraud that's taking place in the commercial system. So we know the Attorney General is not going to reply. But the way we're structuring this, and I'm just going to skip to the bottom so you can see what I'm talking about, we're structuring it to create an obligation for the Attorney General to reply, because if the Attorney General remains silent, then it's consistent with supporting the fraud. So again, I said just look for a remedy, because they're damned if they respond, they're damned if they don't respond. But there's another level of science that we're trying to accomplish based on the fact that we know they will not respond, and that is when someone is bringing an action to create money. Remember, because they're bringing quasi-criminal charges, which is a form of money creation in a bankrupt state, because what they're doing is they got to bring these charges, and then it gets liquidated through the court process, which creates funding. There's only now when you look under the Libra Code and martial law and all these things, you're not supposed to use property. You're not supposed to use, the government is supposed to protect private property and all public property. If one says, well, the estate is considered public property because the person is intestate, or they died without a will, or they're incompetent, or they're still considered a minor. So you may say, well, that's public property. But under the legal code and the martial law and the military system, these private agents are not supposed to be using their authority for private and personal gain. So when we run the constitutional challenge against the statute to see if what they're doing is constitutional, and we find that it's not constitutional, then that means, well, if you're not using this public property for government purposes, it's not constitutional. What are you using it for? And then you start looking at the potential violations of the Trading with the Enemy Act, because they're using this public property for private gain. See, when you read the Trading with the Enemy Act, the way that I understand it, it clearly protects both, let's say, the public commercial business, it protects that establishment as well as it protects the private commercial business. So the way that the Trading with the Enemy Act is structured, you can violate the Trading with the Enemy Act by violating a private citizen's rights, his set-off rights and his commercial exemptions. These are the laws of the United States, and if one is going against those, especially the commercial side, and I'm not going way into that right now, that's a violation of the Trading Enemy Act, and it goes the other way on the public side too. Let me get off of that because that's beyond the scope of this. But what I wanted to point out is if we prove that the business that they're doing has nothing to do with government business because the statute is not even constitutional and it hasn't even been enacted in a positive law, then this sets us up for our cross-claim and counter-claim if we're going to bring in certain violations of Trading with the Enemy Act, and we're going to bring in violations of fraud for concealing certain records and things like that. But anyways, let's go ahead and read this and get it out the way and close this out. So I use the term private property. It's not so important on this instrument, but when you're dealing with private negotiable instruments for set off, it's important that you kind of indicate that it's private property. So one, you would know that you're never supposed to tender it in public, and two, you only tender it to, and see, private, if you spill your private instruments in the public, it can come back and get you in trouble. So never try to tender something or bring your private affidavit somewhere and they'd be like, well, let our legal team take a copy of it. We never seen this before. Let us make a copy of it. Don't. First off, it's against the Financial Privacy Act. I think it's something like that. If you really want to know, I can go look it up for you, but there's a certain act about that. But it's I think the Financial Privacy Act of 1970 something. I don't really know, but you can't duplicate instruments. It's just like a postal money order. You can't duplicate it, right? So with your private instruments, don't let people duplicate them. And once we establish that the statutes that they're trying to use against us are non-constitutional, which means they don't really even have a function of government, and we also establish, using the Freedom of Information request and retrieving information, that they are receiving money from the same entity or agency that's prosecuting, then we're beginning to create a clear violation of the Trading with the Enemy Act. And this is especially if you've exercised the commercial exemptions that's in that, because if they're going to stand in the place and oppose, right, they're opposing the laws of the United States for some other purpose, which is clearly private financial gain. This is how this whole commercial prison system works. So we're basically, as we say, we're going in and carving out a remedy and setting up several mini proceedings, and hopefully any one of these mini proceedings can bring the public quasi-criminal proceeding to a halt. Okay, with no further ado, let's go ahead and read over this and close this video out. Okay, so first off, Health and Safety Code subsection 11360 has to do with transporting a controlled substance, and they were trying to get me for transporting and sales for pretty large quantity of marijuana. There's a whole bunch of circumstances in, but we'll just kind of keep it at that so you can understand. You can kind of put into perspective this particular constitutional challenge. Now, mind you, I only raised 3 constitutional questions. You could have pretty much raised a whole bunch of other constitutional questions. There's a lot of different estoppels that you can pull out the Constitution when they try to charge you with crimes that are not really crimes at all. So let's go ahead and deal with those right here. Notice of constitutional question number 1. Is there any proof that Health and Safety Code subsection 11360 was enacted into law in accordance with the provisions of Article 4, Section 8 of the California Constitution governing the creations of laws? In your response, take notice that Article 1, Section 9 of the California Constitution forbids the state from passing any law impairing the obligation of contracts, and the Bill of Rights is a contract obligation binding upon the states, which may not be impaired, which fact voids any possibility of Health and Safety Code subsection 11360 being acknowledged as law. The code being forced on the man is done so without consent. So basically, my first constitutional question, I'm asking, Is it lawful? Well, I'm asking, has this health and safety code even been enacted in the positive law? Because obviously, again, there's hundreds of thousands of laws on the books, but every constitution sets forth the specific criteria of which a bill must go through to become law. We talked about that earlier. So notice of constitutional question number 2. In accordance with the California Constitution, is it lawful to force the man into suretyship and force the man to participate and service a contract identified as Health and Safety Code subsection 11360 without his consent in deprivation of his life and liberty? In your response, Attorney General, take notice that Article 1, Section 1 of the California Constitution, which is also a contract trust, guarantees the people the right to liberty, property, safety, and privacy. And on this basis, bonding the man, jailing the man, and forcing the man to contract under the color of California Health and Safety Code subsection 360 under threat of duress, jail without consent, trespasses on the inalienable rights of liberty, property, safety, and privacy. And here's one of the more powerful questions, because you remember they always say involuntary servitude or slavery is prohibited and outlawed except for the punishment of a crime. So we have to kill that presumption that these victimless quasi-criminal claims that they're using to create money and escrow funds from the estate, we have to deal with the truth of the matter and kill the presumption that this is a crime. Okay, so the notice of constitutional question number 3. In accordance with the California Constitution, does bonding the private man into a forced contract under the color of California Health and Safety Code subsection 11360 violate the provisions of Article 1, Section 6 of the California Constitution prohibition against slavery, wherein it states involuntary servitude is prohibited except to punish a crime? I got to take this out. I don't really need that to be there. I challenge the presumption that Health and Safety Code subsection 11360 identifies any actual crime, or that the provisions of the code include the proper elements of a crime according to the law. In every criminal trial, the prosecution must prove the corpus delicti, or the body of the crime itself, the fact of injury, loss, or harm, and the existence of a criminal agency as its cause. By nature I am free and independent, and I have an unalienable right to be free and not to be a slave. Furthermore, the law provides that the man should not be surety for the debts of a person, and that's in Proverbs 22:26. We're using the biblical and ecclesiastical law because that supersedes the estate law. It supersedes the foreign estate law that they're operating under in their commercial admiralty law. It's a higher form of law, and that's one thing that you learn when you study law. You use a higher form of law when they're trying to come at you with the lower form of law. And then I further put in here that biblical law at common law supersedes all laws, and Christianity is custom. Customs is law. And so there's a case law in here. I also put the law. Yes, this case law also talks about where Congress declared that the Bible were the teachings of God. So cut through some of that in there. At no time did I willingly or knowingly consent or agree to be surety under bondage for the contract number 1, 2, 3, 4, etc. That'll be the booking number, the bonding number, whatever. When they first arrested you and tried to charge you with this. So you're basically stating that at no time you willingly gave consent or anything else. And that's because under the Constitution we've already established that this cannot be a crime because it doesn't have the proper elements of the crime. There's no proper accuser, right? So we're also establishing that we are not consenting to this. This is done under duress and coercion. So we're basically pointing out, and I will read it right here. I question to what extent the Constitution authorizes or provisions that any agent of government may force a private citizen to service a contract which has the effect of creating money and profit. I further question whether or not such activity can be defined in any other terms not covered by the definition of slavery. So you see where we're going with that? For a public officer to remain silent on the matter, right? So because remember, the Attorney General has up to 60 days to respond to this. So we're going to create a provision to which she's required to respond. Right? So for a public officer to remain silent on the matter of a constitutional question and the institution of slavery being protected under a covert system, some spelling errors in there, of 4 statutes, to create false crimes or commercial crimes that are in fact outside of the elements required by law makes apparent the extent of silent fraud of slavery and genocide of the Americans of African origin. I kind of jumped in there because I wasn't really talking about the slave trade as relates to African Americans. When I actually have other documents where I have statistics and things like that, which I can actually bring in later if necessary with the cross claim. But hopefully, I don't think you would ever have to get this far unless you really did something crazy. And I did, and I had some stuff going on. Okay, so understand that. The last part is silence can only be equated with fraud when there is a legal and moral duty to speak, or when an inquiry left unanswered would be intentionally misleading. We cannot condone this shocking conduct. If that is the case, we hope our message is clear. This sort of deception will not be tolerated, and if this is routine, it should be corrected immediately. And that's another very powerful case law. Okay, so once you finish the letter, you pretty much send it to the Attorney General as soon as possible. Registered mail, restricted delivery. Include the actual instrument that brings about the situation you're challenging. So that'd be a copy of your booking receipt or a copy of the citation or whatever you're working with. And this actually gives the Attorney General the time to go behind the scenes and potentially resolve the matter. I guess this is something else I'll speak on before I close out the video so you can get a better idea of the interworkings or what's going on. So remember earlier I was talking about the oath of office and your acceptance of the oath being a security agreement that creates attachment and enforceability to a debtor's collateral under UCC Article 9, and that collateral being the insurance policies and everything else. Well, so this might give you a little bit better understanding why this type of matter is handled at the Attorney General's office. Whenever you look at the insurance held for municipal agencies, usually the Office of Risk Management, which pretty much analyzes potential risks that can cause the corporation money because they're doing business. And see, this is the corporate side. This has nothing to do with the government side, which almost all of it is the corporate side. Risk management is kind of like that final decision maker, because whatever they're going to do, they're not going to engage in things that are for sure liabilities. So usually I found when I request for oaths of office, insurance policies and things like that, this is always handled at the attorney level. If you're dealing with the county, it'll be the county attorney. If you're dealing with the state, it'll be the Attorney General, right? And if you're dealing with the United States, it'll be the Attorney General for the United States. So really what they're doing with this constitutional challenge is they're kind of doing risk management. It's, as I said before, the Constitution applies to private citizens, and the Constitution is the only bona fide security agreement or contract that you can enforce with these courts, because they have that security agreement, which is that oath to support and defend that Constitution. So basically, it seems like if there was a such thing as a public remedy, your constitutional rights is the only thing that you can rely on to shut the court down. And when you're doing these constitutional challenges, although on one level it may seem like it's all about the Republican law of the land, really what you're doing is you're presenting a bill, almost like your Bill of Rights, and you're giving them notice of a potential liability. So again, if they're not going to come out and bow in the public and say that, hey, you beat us, and yes, this would be violating your rights, but I think if you do this and you know where you're coming from, they are going to afford you a remedy. So that's going to conclude this video. Thank you for watching, and if you want access to all of our templates, you already know what to do. Visit thctrust.org, create your free account, log in, and if you want to upgrade to get all the template access, join the premium subscription group.